So today, we're going to dive into a really complex and honestly super important legal fight that's been happening in the United States. We're talking about the battle over mandatory immigration detention and that fundamental right to ask a judge for a bond hearing.
I mean, think about it for a second. In the U.S. justice system, the whole idea of a bond hearing is, well, foundational. It's your chance to ask a judge, hey, can I be released while my case moves forward? But what if that chance just isn't there for you? This one simple question is really at the heart of decades of legal battles.
So how is that even possible? How can someone be detained without getting a hearing? Let's take a look at the legal machinery that makes it happen.
The key phrase here is mandatory immigration detention. And what's really fascinating is that distinction it makes. This is civil confinement, not criminal. But still, people can be held, often in places that look and feel just like jails, without even that first chance to argue for their own release.
Yeah, this whole practice immediately bumps up against a core constitutional idea. The government can't just lock someone up and throw away the key. And it's that tension right there that really sparked the first big legal challenges.
And that tension led directly to a landmark court decision that gave us our first major principle, what's now known as the 6-month rule.
So the first big answer came way back in 2001 from the U.S. Supreme Court. It was in this huge case called Zedvitas versus Davis, and it took the question of indefinite detention head-on.
Okay, so here's the crucial takeaway from Zedvitas. The court basically created a 6-month timer. If someone has a final order of removal, but the government can't actually remove them within those 6 months, and it's not looking like it's going to happen anytime soon, well, at that point, holding them any longer becomes unconstitutional.
And look, this was a massive victory for due process, no doubt. But if you look at the fine print, the ruling only applied to people who already had a final order of removal. That left a giant, gaping hole in the legal landscape.
Exactly. What about all the people being detained while their cases are still being decided? You know, those proceedings can drag on for months, sometimes even years. The Zedvitas rule just didn't cover them. And that, of course, led to the next big phase of this legal fight.
So, since that 6-month rule was off the table for ongoing cases, the next legal challenges had to focus on a totally different idea. Not indefinite detention, but unreasonably prolonged detention.
And this next chapter was really written in the Third Circuit Court of Appeals with some really influential cases like Diop versus ICE. Organizations like the ACLU's Immigrants' Rights Project have been doing a ton of work on this, and their advisories are super helpful for understanding these really complicated decisions.
And wow, this quote just nails the court's logic. It gets right to the heart of the due process argument. The court was basically saying, look, we get that the government has an interest in detaining someone, but that interest isn't infinite. At some point, the crushing burden on a person's freedom is just too much to justify without a proper hearing. But here's where it gets interesting. Instead of just slapping another 6-month clock on it, the court went down a different road. It decided that for these ongoing cases, you had to figure out what was reasonable on a case-by-case basis. This led to a more nuanced and, yeah, a more complicated legal test. So if you're going to go case by case, you need a new standard. How does a court actually decide when detention has crossed the line into unreasonable? Well, that brings us to what's called the good faith test. In another case, Chavez-Alvarez, the court laid it all out with these 3 key factors. First, is the person actually fighting their case in good faith? Second, plain and simple, how long have they been locked up? And third, what's the outlook? How much longer is this whole thing going to take?
Now, this is the part that might really surprise you. What does a good faith claim actually mean? You'd probably think it means a claim that's going to win, right? But the court said, nope. Even if your claim has already been shot down by lower immigration courts, it can still be considered a good faith challenge as long as it's raising real issues. That is a really critical distinction.
So for years, the law was kind of inching forward through these court cases, building this framework for when a bond hearing was necessary. And then, in 2025, the government rolled out a policy that just completely upended the entire playing field.
And that move sparked a brand new, incredibly high-stakes legal battle over who even gets a bond hearing in the first place.
I mean, just look at this timeline. You can see how fast things went off the rails. For decades, it was mostly discretionary detention. Then boom, July 2025, ICE issues a new nationwide no-bond policy. By September, it's binding on all immigration judges. The whiplash was immediate, and so was the legal fightback. By November, a federal court had to step in.
So a whole coalition of groups, including the Northwest Immigrant Rights Project and the ACLU, they jumped into action. they filed this massive nationwide class action lawsuit called Maldonado-Batista v. Santa Cruz to go right after this sweeping new policy.
And guess what? It worked. The court struck down the policy, flat out calling it unlawful. It confirmed that the people in this nationwide class, all the folks detained under this new rule, were in fact eligible for a bond hearing in front of an immigration judge.
And that brings us right up to the present day and the continuing fight to make sure this hard-won right to a hearing is actually, honored in practice.
All right, so let's put all the pieces together for a sec. This table gives a pretty great summary of the whole journey. We started with Zadavitas, which set up that 6-month rule for people with final orders. Then came the DIOP cases, creating a reasonableness test for people with ongoing cases. And now, most recently, Maldonado-Batista pushed back hard against that new no-bond policy, confirming the right to a hearing for a whole other group of people.
But here's the thing. As the source material for the Maldonado-Batista case shows, winning in court is just the first step. There are reports that some immigration judges have been told to basically ignore the court's order, and that leaves us with this final, really profound question. If a court says you have a fundamental right, but parts of the government can just refuse to comply, what does that right actually mean in the real world? And that is the central question on the front lines of this legal battle today.